Advocate Sikka, some of the questions and pertinent points that Ashok here in the studio is certainly raising, and also, your initial thoughts on the verdict that has come out.
Just I am telling you that around 20 years back, there was a Allahabad High Court judgment in which I had got the 6 month waive off due to certain reasons that after 1 year they remained separately more than 1 year. I said that there is no purpose. Thereafter, they have not started a consultation. Even they cannot reside together. So, in that case, 6 month waiver is something different. But in every case, court cannot directly grant divorce under 142. 142 is constitutional court, and High Court, Supreme Court has power to exercise this, but lower court cannot exercise. Under Section 13B, if there is mutual divorce without seeking the gestation period of 6 months, then court can waive off on the basis of the ground.
All right, and about Article 142 of the Constitution, there are many questions that have now come out in terms of how and when the Apex Court is going to be using these sweeping powers.
142 is an extraordinary power in those circumstances that if you have contested lower court and you are coming to Supreme Court. Supreme Court will not decide every divorce petition. There will be certain points in respect of the welfare of the children and their maintenance, their compensation. In respect of that, the wife is earning or not, husband is earning or not. It depends all these factors. So when a person who are well off and they are interested under 13B, then cooling period can be waived off.
All right. Ashok, economic rights of the children is something that I heard one of the judges speak about as well. Do you think this particular case, you spoke about alimony rights, you spoke about various adoption, allocation, succession, all of those things will now come into the fray as well. 13B, it seems, is untouched. Do you think it's going to be, there is a possibility that it might fiddle with public policy here, this verdict?
Well, as far as the stated public policy is there, which has been spelled out by the Parliament, it is that the cooling off period has to be there. Now, what the court is saying is that what we are witnessing is a new trend, where couples are coming to the Supreme Court straight away, saying that, look, we don't want to wait for another 6 months before a divorce can be pronounced. You have to understand that these are the couples who are in a rush, who are in a hurry to hatch on or to latch on to another marriage. Usually what happens is that the process in the lower courts is so lengthy and drawn out that the process itself takes 3-4 years for a divorce to come through if it is not contested and if it's mutually acceptable to both the parties. What the court is saying is that, look, first we will see whether the first fact is whether the marriage has broken down in such a manner that no repairs can be done. Number one. Number two, we will see whether both the parties to the marriage are agreeable to divorce or not. The third part we will see is that it's not just the husband and a wife who are parties to a marriage. There could be children. There are other children have rights. The woman has rights. The man has rights. Those rights have to be adjudicated first and only then. Now, what has really happened in the past is there have been a large number of cases also that I have seen where couples do apply for mutual divorce. And this is a provision of law which was misused. What happened was there were instances where educated officers who were married off early in their life because of their commitment of their parents got married to somebody who is illiterate. But to honor the commitment their parents or grandparents did, they got into that marriage. And once they became sufficiently economically well off, they wanted to divorce their first wife and hatch on or latch on to another person. So what they did was that a person, a woman who was illiterate, who came from a rural background, who did not knew her rights, she was given one lump sum of money. Say it was agreed that 20 lakhs would be paid to the woman by the husband to get out of the marriage, and he would ask her to sign a petition for divorce by mutual consent. We have seen a lot of such cases come up, and it was precisely to tide over any misuse of the provisions of law that the court had said, that the parliament had said that you need a 6-month waiting period. We'll ascertain whether what you are telling us is true or not. There could be false facts which could be peddled in front of the court. There could be circumstances where a woman could be pressurized. There could be circumstances where the man in the marriage could be under some sort of a duress. So these are basically speed breakers which had been introduced by the parliament. Now the Supreme Court is saying that, look, the provision of law stays. The 6 months cooling off period will be there. But if you come to us and if you are able to show to us
that you don't need the 6-month period,
that you don't need the 6 months period, and you have entered into an agreement and put to rest all our concerns with respect to child rights, maintenance, alimony, welfare, once that is done, then we'll possibly waive off that 6-month cooling off period. So what will happen now is that there will be a flood of litigation in the Supreme Court. Now, who are the kind of people who can come to the Supreme Court are generally the wealthy of people, people who can afford expensive lawyers. Coming to the Supreme Court or fighting a case in the Supreme Court even for a year or two is not a cheap proposition. It takes money. Lawyers charge you money. But one thing why people rush to the Supreme Court is that they believe that they will be able to get justice quickly.